Good morning, Jim Lampert again, back for the Q&A session, this time out of section 2. A couple of things to start. There was one question that I'm afraid I just can't answer at all. It was basically who are good employment agencies in other developed countries. And frankly, I didn't know and it wasn't really clear where to look. Second, there were a couple of questions, and you'll see as you go through, where I wasn't quite sure what the question was asking. So if ever who submitted them thinks that I'm giving the answer to some question other than what they asked, let us know, and we'll try to follow it up at the tail end. I've broken the questions down into 4 or 5 different subjects. They don't quite all fit together, but it was better than just running through them randomly. And the first group is probably, obviously, patents. And the starting question is really a big one. I have my ideas, but how do I use them? Well, this is another one of those questions, a good place to start, where I'm not quite sure what use means. If the question being asked is how can I be sure that I don't infringe on somebody else's rights when I use them, we went into that briefly in the ongoing session, and there are really 2 aspects. First off, be very careful of where you got information. But the second is more difficult. How do you run a decent, what they're called a freedom to operate search to figure out what other people might sue you on? And unfortunately, the answer is not easy because, as I said a couple of weeks ago, no search is complete. If the question is, look, how can I use them? How can I get somebody to support me? The obvious answer, you have to develop a team. You have to get that team together, you have to get your business plan together, and then you have to go out and sell it to somebody. What's the future of patents? Well, I think they have a future. Every country in the world seems to think so. The basic reason for them, historically and justification today, is that if you don't have some promise of exclusivity, you will never get people to invest the money that's necessary to develop new things. Why use them? And how do we advocate for the use? Kinds of go together. They can be very useful. They can be useful and they are essential for a lot of companies, particularly in the biotech area. Remember that patents have both pluses and minuses. We went into some of that a couple of weeks ago. And this slide is actually, as is the next one, from a couple of previous sessions. What's the plus? It's the only thing that can cover anybody else. It may prevent other people from selling competing products into your markets. It may increase the perceived value of your company, though a lot of that depends on how sophisticated the person evaluating not only your technology, but your basic marketplace look like. And it may give you some ability to shoot back when someone walks in, and you've heard me say this before, and tells you to stop doing something because they think they have some IP. Those are clearly the pluses, and those are the reasons that companies basically seek patents and want to use them. As we also discussed a couple of weeks ago, there are obviously minuses. This in major ways is a balancing act. What are the pluses I could get out of a patent versus what's it going to cost me, not only in money, because they are expensive, but in terms of other things. Like you have to disclose some technology. If you don't disclose it in a patent, do you have a chance of keeping it as a trade secret? It will be limited. Patents are always limited to their claims, and you nearly always disclose a lot more than what you claim. There's no real way to get around that. You obviously have tests you have to satisfy if you're going to get a patent. And we'll get into this, I guess, beginning in sessions 3 and 4. What's it mean that it has to be new? What's it mean that it has to be useful? What does it mean that it has to be obvious? What does it mean that a patent has to be for the right kind of thing? Because as we'll talk about, I guess it's in the next session, there are some areas around the world where you just can't patent certain types of things. But basically, there's some in the software, computers. They've been a problem that have vexed patent attorneys, well, since I started some 55 or so years ago. And more recently, you're getting in problems in the biotech industry, particularly in medical treatments, where there's a tremendous amount of expensive research. But is the underlying discovery something you can get a patent on, or what do you have to add to it? The other basic limits on patents are, okay, they're basically limited to some period of time, and you've got a gap period before it's going to issue that creates some problems. If your product isn't going to be useful for 5 years and it takes 7 years for a patent to issue, why should that patent have any future? Going back, the next question that was kind of asked was, what's evergreening of patents? Well, I'll admit I went back and looked this up because I had an idea, but I wanted to make sure that I got a little more information. Frankly, it's an issue largely in the pharmaceutical area, where when a patent that is extremely profitable in terms of the product it covers runs out, waiting around the corner are always a lot of generic producers who want to compete with you and are frankly going to cut your margins a long, long way. We'll talk about it when we get into litigation and damages, but there have been cases that have decided that your profits are so big that if you sue, you're entitled to collect something like 75% of the value of everything that guy you sued has. Those are big profit margins to protect. So a pharmaceutical company is always interested in figuring out how to extend the useful life of this patent. There are 2 or 3 ways that they do it. First off, they try to slow down the other guy's regulatory approval process as best they can. Often, and you may have seen some reference to this in the press, there'll be litigation, and the outcome of the litigation is that the patent owner ends up paying money to the infringer, which isn't usually what patent suits are all about. It's usually the patent owner trying to collect money from the infringer. So what does the patent owner get in exchange for paying somebody else who's infringing this patent? Typically an agreement that that other person will stay out of the market, a market they otherwise would be perfectly free to pursue, assuming they managed to invalidate the patent, and give effectively a longer monopoly to the person who has the patent. They may agree to stay out for several years after the patent would expire, and the market would otherwise be completely wide open. And the third way this happens, from what I understand, is if you have a patent on a drug, you've spent 10, 15 years getting all of the MDs all over the world to say this is the drug they should prescribe. But before your patent expires, you come up with a minor tweak. It may not be earth-shaking in any way, but it makes for a slightly different, and at least from an advertising point of view, improved profit. And you convince all the doctors to switch to this improved product. And guess what? Somehow you manage to get a patent on the improved product. So your original patent runs out, and what do all the people who want to compete with you, what are they faced with? Well, they're faced with the new patent, the new improved one that they can't make. They can certainly make the old one, which is probably very close to as good as the new one, but nobody will buy it because they've now convinced all the doctors only to sell the improved one. In other words, the green will be ever coming in, even though your original patent has expired. The last couple of questions here are ones that have come up repeatedly, both here and in most other classes and sessions that I've dealt with. Okay, I get a patent in the US. I get one in Syria, as the question asked. How do I make that patent international? And unfortunately, the answer is you don't. There is no such thing as an international patent. There are conventions that make applications, particularly in Europe, there's another one in Africa, where a single application may be examined by a central agency for a group of countries. But once the patent issues and it goes down to each individual country, and you have to pay to take it from an international PCT application or European application down to the individual countries. Europe in particular has been trying to work on a European patent. They keep saying they're almost there. They started saying they were almost there when I was a great deal younger than I am today. Hopefully they will make it sometime soon, but that will still mean that you'll have to get individual patents in a lot of individual countries, of which Syria is clearly going to be one. When you get to copyrights and trademarks, the situation is a little different. Although there's no global patent, though there are some semi-global European PCT patent applications, copyrights are essentially worldwide. The vast majority of the countries in the world belong to one of the copyright conventions, and there are 2 or 3 of them. And the net of that is that if you get a copyright in your country, you basically get a copyright in all of those other countries. There may be slight differences in the rules as to what that copyright covers. As a rule, you don't have to go register it anywhere. The US is about the only place you have to register. But copyright protection, at least as a name, is worldwide. The scope of that protection varies greatly, and one of the big variants is obviously, as you would expect, when you get into the software area. Trademarks kind of fall into the middle. There are conventions, the Madrid Convention is the major one, through which you can get trademarks or get them on the road in a lot of different countries. If you don't go that route, you really do have to start thinking about it country by country, and more importantly, country market by country market. But you can do that. The big advantage of getting in using Madrid is that frankly, you cover a lot more and you save a fair amount of money, even though things eventually get all split up into various countries. It also, you get a difference in some countries. Do you get a trademark, and I think I mentioned in the first go around, only by, if I didn't, I should have, by registering it, or do you get a trademark initially by actually using it? Most countries, the issue is registration. But using conventions, you can, sort of as you can for the patent PCT, go globally, but eventually you do have to split things down. The next set of questions is really related to, okay, I want to apply for a patent. The first question was, a lot of companies say, gee, we'll help you. For $199, we will make you a multi-billionaire. How do you know which are reputable and which are reasonably priced? Well, the first thing to recognize is the majority of those ads will only give you a provisional patent application. They'll tell you for not very much money, they will file a provisional patent application. And let me leap kind of down to the last question here. I think I've mentioned it to some extent. What is a provisional patent application? Well, it's something you can file in this country, and it sits there as sort of a place marker for a year before you have to file what I'll call your real application. And they vary from everything to put a cover page on a paper that's about to be presented tomorrow, what frankly looks like a real application and could have been filed as a real application, but somebody wanted that extra year. I would guess that that $199 application that the people who advertise are going to sell you is going to be a lot closer to the paper that's going to be presented tomorrow with a cover sheet that probably is not sufficient legally to do you much good in getting that extra year, because to get that year, that first provisional is supposed to disclose everything that you would have to disclose if you filed the real one. Be careful of them. How do you know which are reputable? very, very difficult to see. If you look at their site, you'll find most of them will refer you to their patent attorney. I know no reason to think that they're not reputable, but I don't know how much faith I would have in the fact that they're really going to do the job that you want to do. Remember, your patent has to be tied to your business. And unless you have enough communication with your patent attorney so the patent attorney understands what your business is and what your goals are, he may be, or she may be perfectly reputable, but they won't do you much good. Price, always ask. Do I have a year to file after I disclose my idea or discuss it? Simply a discussion is probably not prior art anywhere in the world. But that gets iffy. How big is that discussion? What else do you talk about? What do you give people? What do you show them? If you're in the US, and we'll talk about this again, I guess next week, 2 weeks from now, you have a limited 1 year to file after you disclose. It's not all encompassing. It's not what was in the prior patent law. The new law isn't quite as good, but Congress was not willing to throw away the 1 year of grace. The problem that exists and will always exist is that even if you get a year of grace after you've done something that might start the prior art clock clicking in the United States, it doesn't help you in any patent abroad. Next question was kind of fun. I first had to figure out what in blazes is this all about, and figured it was YouTube. I then had to figure out that I didn't have to watch the first 34 minutes. But what it seemed to come down to is, again, I had a good idea. And then I found that somebody else, and this is YouTube, the people who I guess owned Purdue, having made billions of dollars on opioids, are now planning to patent, if they haven't already, an anti-opioid. And I'm guessing that whoever sent this question in had a similar situation in which they found that someone was trying to do exactly what they were trying to do. That may be a real impediment. In a patent world, the question is going to be, is there only one way to do it? And did the other person get there with the one that's first? In the marketing world, if somebody else is there first, getting in second just may not do you any good. Biotech, patents are mandatory. That's actually pretty close to an accurate statement. You get into the biotech world, and I'll use EPO, Amgen's EPO, as an example. Amgen is a billion-dollar company because of erythropoietin. And it convinced a court 30 years ago that it and Not Genetics Institute here in Boston basically figured out how to create EPO first. Had Amgen lost that suit, Genetics Institute would be a billion-dollar company. When do you apply for patent protection? Well, if you'll remember, I said last work, apply early is the typical rule. You really do want to file first. You would have to get to some stage of development so you know what you're filing on, but you don't want somebody else to beat you into the filing line, because first to file is going to win practically everywhere in the world. So once you know what are the basic requirements for what you're going to do, really start thinking about a patent. An early patent can support early work can support broad patents. You're clearly going to finesse things, improve them slightly, but hopefully you already have the core idea. And if you're first, you avoid prior art of somebody else who was doing the same thing and filed a little later. And never make the mistake of assuming that you're the only person in the world working on any particular problem. There are a lot of smart people out there, and I'll give you that you may be one of the smartest, but there are others who are trying to fall very close behind. Problems on filing first? The real problems on what can you add to a patent. If you find you have to add something, you may not have known about it at the time you first filed. You may find that what you first filed is frankly not new, although you thought it was, and you discovered later what really made things work But if it's not in your early patent application, that early patent application won't do a whole heck of a lot of good. Hopefully it'll be better than the one you might get for $199 somewhere else. Somebody asked, are there templates for provisionals? The answer is there probably are a few out there, but frankly, talk to somebody on what you need to file. Among other things, provisionals are supposed to be cheap, and the cover sheet on a paper is cheap. If you need to write a full-fledged patent application, frankly, you're going to spend a few $1,000s having somebody work with you on it, even if you can keep the cost down by doing a lot of the technical writing yourself. If you're going to look at a template, look at a lot of them, and then talk to somebody about which ones give you what and what do they leave open in the way of problems. How do I get a patent for my company? Well, I assume that what this question was really asking is who files for the patent? Well, in the US, it's not the same abroad, but in the US, the inventor is the initial person whose name shows up in an application. The application will be assigned, and here I assume it would be assigned to quote my company, and my company then will basically handle all of the goings on in the patent office, all the answering stuff. But the process for getting a patent for your company is pretty much the same as getting a patent for yourself, with the very important proviso that hopefully the company will pay for it. And they may have a better idea in terms of the value of that patent for your company that you're obviously supporting, what the patent should look like. Is every kind of business suitable for a patent? The answer is clearly no. Some things aren't patentable. Some things would be far better off kept as trade secrets, particularly if the product's going to only have a useful life of a couple of years. It depends on the business, depends on where the business is in its lifestyle, and frankly, it depends on how many patents you're going to try to get and how much money you want to spend. You file for a patent. What about a search? Typically, your patent attorney herself will not conduct a search. They will have someone else conduct the search. I always had people that I had used for I used different people for different types of technologies. I've used different people over time to run a search for me and obviously for my client, because frankly, they're a lot better at it than I am. They do it all the time. It's their job. It's all they think about. And they tend to get the information that I would simply walk past. That search may well tell you that somebody else had previously done what you invented or something pretty close to it. Problem with searches is always that they're incomplete. There are millions of patents in the US. There have to be tens of millions of technical articles. There have to be tens of millions of European and other overseas patents. Nobody is going to find them all. And if they can't find it, or they don't find it, patent office may or may not find it later. And frankly, the person who's really going to spend money on a large search, which is going to be someone in a piece of litigation farther down the pipe, has a greater chance of finding it. A search will give you a guide. Where do you search? Ask yourself who is likely to have done something like this. Who are the potential competitors? It's typically worth searching their patents and pending applications, the ones that have been published. They're likely to have something. They are also the ones who are far and away the most difficult to deal with if you find you've got a problem with them later. Beyond that, maybe you know who the people working in the field are. Try name searches. Subject matter may do. The problem with a subject matter search, particularly, I'm a mechanical engineer, but particularly as I found when you got into the chemical and biological areas, actually it's not quite fair. Chemistry was probably pretty good, but different people call things by different names. There isn't any universal terminology that you only use one word to describe something. So what words do you search? Another reason, frankly, get the search done by somebody who is hopefully knowledgeable in the field and has a lot more experience in running searches and how properly to do them at a reasonable cost. And you can spend, you're always going to spend up to $500 to $1,000 probably on a search. You can spend a lot more than that. When's it worth it? When do you wait for the patent office to run the search? What's your goal? Is your goal to get a patent issued? Or is your goal to win in litigation? Well, if you don't get it issued, you never get to litigation. So let's start by getting it issued. And if you let the patent office run the search, and you have to tell them what you know about it that's old, and they don't find anything that's disqualifying, you probably have a fairly decent asset that you can make some use of, whether or not it ever goes into litigation or it's likely to be really tested. Food and beverage. No, I skipped one. 2 authors for a patent. But I'm assuming the original patent has joint inventors. One of them wants to add something new independently. The terms that leapt out to me on this question are add and independently. You can't add anything to an existing patent. You can't add anything to a pending or existing patent application. The patent itself you can't touch. If you have pending applications, you can file a new application. The jargon is usually a continuation in part that will have both what was in the original patent referred to and the addition. Whose name goes on that? Who gets this independently? If that continuation in part names the same inventors, there are some procedural advantages. If, on the other hand, it's a straight new patent application and names only the second inventor, that first application is much more likely to be prior art to the second. So exactly how you would want to file this, I'm assuming from the question you would want to file a new application. Whether that should be filed as a continuation in part of the old patent, assuming you still have the ability to do so, or whether it should be an entirely new application, depends on a lot of things. What's your present relationship with this other inventor? Who owns the current patent? Individuals or a company? Who's going to own the new one? What are the chances of getting one? You're going to have to talk this through and talk it through in some detail to figure out exactly where you want to end up and what might be best for both of you who own the current patent and for the person who's come up with something, I will assume, worthwhile, that probably is worth trying to get a patent on also. Food and beverage. Let's start off with food and beverages per se. The old saw is that recipes aren't patentable. Beverage mixes may not be patentable. If they're not patentable, you don't have any register ID, I assume, is talking about trying to get a patent on it. Your first step is going to be to decide, is this the type of thing that's going to be patentable? And you're going to have to go back and look at the current status of the case law and statutes in whatever countries you're interested in to see where food and beverages fall into that you can get a patent, you can't situation. What about the product? Well, it's obviously going to be the subject of a patent if you get there. But if you get into food and beverages, you have a lot of other federal agencies looking around, chief of which is probably the FDA. What do you have to do to get their approval? It's completely distinct from getting any approval from a patent office. But you may have to register your idea and get some approvals from them or from some other agency if you're in a particular field, and I frankly don't know exactly what those would be, if you want to market the product. Because what you can market depends not on patent protection or patent being granted, but what other laws and regulations in your potential market say you have to do, frankly, to prove food and beverage are safe, and the extent to which they are equivalent to marijuana brownies, that depends on state law in this country, and that's still getting all mixed up. Ownership. All of these questions basically come down to something we talked about in the earlier session. Labeled it copyright, you paid for it, but do you own it? And frankly, didn't get to the last bullet to say essentially the same rules apply to inventions. What's the bottom line, be it a copyright, or be it a patent, or be it a trade secret? Initially, the person who created whatever it is, or came up with the idea, starts off being the owner. When will that not be so? The overarching situation is it won't be so if there is some policy you've agreed with. Say you're going to MIT. MIT has all kinds of policies on when things belong to them, and by partaking of some of MIT's benefits, you sort of acquiesced in those policies. What type of agreement might you have reached with somebody else? And I think in the first session, we looked at some sample assignment agreements. The one in the first session, I think, said anything you do while you're working for me that relates to your job or close to it belongs to me. You did it on my time and I paid you for it. So you start off with, do you own it or does somebody else own it? Unless you've signed something, or unless there's an overlying policy that somehow comes into play, you typically own it, not the company. Work for hire, we talked about earlier. There's the equivalent of hired to invent in the invention world. If something is truly a work for hire, or you were hired to invent, the question to ask is, okay, did you do this as part of your regular paid job? In which case the law in most places, copyrights clearly, others state by state say, the person who paid you, the person who hired owns it. If you're a consultant, if it's outside of your work, not part of your regular employment, there's got to be an assignment. So with that, let's go back and go down this kind of list of questions. How can a teacher own their intellectual property copyrights when teaching? Presumably, if they developed them, they own them. I went through this basically, there's a couple of conversations with MIT is, look, I'm developing all these. I have the copyright in all of this, but MIT wanted and absolutely willing to give them a license to do with them for what it wants to do, for educational purposes, for teaching purposes, for running this. And frankly, if anybody else wants to, MIT wants to run this type of thing, MIT can do it. But the teacher can own simply by virtue that they will be the initial owner. And I don't think it makes any difference that it's a nonprofit or an educational startup. That educational startup needs to understand what its rights are to use what the teacher has done. Not only perhaps to put on its own class with the same materials with somebody else when the original class gets too full, but also to make some improvements on it and develop it, in which case more than one person may have some types of rights in the material. You've got to get an agreement. Teacher and that nonprofit have to sit down and figure out what they both really need. And it shouldn't be too hard to do. The teacher needs freedom, quite broad freedom. The startup needs freedom so it gets the benefit of what the teacher brought to it, but obviously to go into competition with the teacher would be something quite different. What's the best way to own it? It can be owned individually. You could have trust, you could have partnerships, you could have corporations. It all depends, how does it fit into the overall business picture of the startup? But it steps back to, okay, the startup may own IP if it's assigned to it. But again, is there going to be a license back to the person who created it for what they can do? This all gets into what do you need, tax reasons, I may want to have an LLC, I may want to have a corporation, some type of trust if I want to just pass it to my kids. Get legal help from somebody besides an IP lawyer, because this is the crux of what type of company is this educational startup going to be? What rights does it need? What does it need to own? What can it simply license? And what does the person who developed it and is giving an assignment or a license to the educational startup need to retain? I didn't really understand the next question, what the problem was. If somebody could explain to me, supervising us hold your thesis, I guess my basic question is why? I'm guessing, and I'm simply guessing, that basically they don't want that information to get out. They're trying to maintain it as some type of proprietary information that won't make the public world until some time after the supervisor, who may be for a company or maybe a supervising researcher who's working on a grant for here or for Stanford or somebody else, has to do to qualify and comply with the terms of that grant. What do you want to do? Do you want to basically publish it so your name's in print? Is this something you want to go forward and look and try to get a patent application? What type of agreement do you have, if any, on when you can publish or go ahead with the fruits of your work, which shows up in your thesis? I don't think there's a simple answer to the question. I think the simple question I ask is, why does the supervisor want to hold it, and what do you want to do with it? At which point, if you have an understanding of those two, you may have the answer of what you can do, and you may make the supervisor a little unhappy, but in some cases, so be it. Or the supervisor may say, hey, we've got an agreement that says you can't do a damn thing, in which case, you're going to be a little unhappy. It's all, as in most of this stuff, it's always going to be factually dependent. The next one really scared me. I have no idea how a patent is automatically seized by anybody according to law. There may be, you may have had an agreement with whoever ran this competition to assign any patents to them. You may have had some agreement as what would happen, but the typical situation, as we started off on this group of slides, is that you owned it initially, unless there's some agreement that changes things. If any person who put this question in is on the line, shoot us a follow-up so I have some better understanding of exactly what the situation here is, because I'm frankly not entirely clear. A couple of fairly, start off with simple questions. Are copyrights not considered enough by investors? Unless you are perhaps in the music business or in the novel publishing business, I think the answer is usually no. If you're in one of those businesses, you're in the performing arts, you're an actor, you're a playwright, you're a songwriter, you're a performer, copyrights may well be enough because frankly, there isn't much of anything else. Patents don't protect contents of a book. They don't protect a tune. They don't protect the words to a tune. They don't protect the way Beyonce sings that tune. All of that's wrapped up in copyright, the performance right, and a lot of other things. If, on the other hand, you're talking about something that falls into the useful category, that's part of the metes and bounds of patents, copyright protection typically doesn't give you much. A copyright on a book that describes in detail how to make a perpetual motion machine does not give the writer of that book the right to be the only person to make a perpetual motion machine. It only has the right to prepare some derivative copies, make other copies of the books, etc. But there's no right to use the information in a copyrighted material of that type. It falls into the useful and that simply isn't uncopied. So we have patents, which are about the only way that you can protect a perpetual motion machine. Though, as I think I may have mentioned, a perpetual motion machine is the one area in which the patent office insists on getting a working model. They used to insist on working models 150 years ago on practically everything, or at least models. If it's a perpetual motion machine, they still want a model and they want you to prove that it works. They don't think it exists. So we insist on patents because they are the only things that will protect what you and your company and an investor are putting their money into. The last part of this is to prevent competition from doing better than you. You've walked smack dab into a major policy question. To what extent should a patent focus on protecting the person, the rights of the person, and permitting them to recover for their initial work in developing something? And how do you use that patent right to promote getting a better widget? One example that people often use is if I come up with, well, the example that was used in a class over in the business school, I patent the idea of having a log cut flat at both ends so I can sit on it. And I get a patent on the idea of something with a surface you can sit on a distance above the ground. Somebody else comes up with the idea of a three-legged stool. Great improvement. That three-legged stool person, what can they do? Would they infringe that patent if they sold their stool? Sure, it has a seat a fixed distance above the ground. On the other hand, who in God's name is going to buy the log? So where are we? Let's make a deal. What typically happens here is that the person who has the basic patent and the person who has the improvement get together so that they can both make a product that the market will buy, which is typically the goal of both. When do you basically, because the competition, have to look back to the basic idea? I use kind of scenario, are they riding on your shoulders? Are they really using what you contributed? If so, the question I would ask is, why shouldn't there be some requirement for them to recognize that they are making use of something new, useful, and non-obvious that you came up with? The second question on this page gets into the idea of trademarks and competitive advertising. How many bottles of this, that, or the other, if you go to your local drugstore, you say, same formula as, works just like, better than. All of the thans, or the X's that come after that, are registered trademarks. Is the person who puts out the generic product, competitive product, permitted to say, mine is just like yours, and to say so in a way that the consuming public will know to what in heaven's name they're referring? Here they're referring to Facebook. People know what Facebook is. The answer is yes. You can use, there is a fair use of trademarks. Are you using this trademark here to pretend that Facebook sponsors your website? I don't think that's a fair reading. I don't think anybody would think that's a fair reading. But on the other hand, you are giving information to the public that they know that yours is a lot like Facebook. That's a denominative, what they call a denominative use. It's proper. And the most example that you see the most often is when you get into comparative advertising. R in a circle, Frankly, that doesn't make any real difference in terms of whether or not you have the right to use the name. The trademark owner is probably happier if you put it there. Query whether for your own purposes you want to. Probably worth putting it on there if otherwise somebody says they're going to sue you because it's cheap and easy to do so. But you're not going to get any better permission if you say, this is the registered trademark of Facebook. Same way that you're not going to get in a better position if you copy something from somebody's copyrighted book and you say, thanks to so-and-so's copyrighted book. The question in both cases is, do you infringe the copyright? Do you infringe the trademark? If you say, in some cases, you're just proving that you did copy, do you want to do that? But it's not going to help you. Exploiting your IP. How do you find if a patent is pending? Really two ways. One is you may see the product that says patent pending on it. The other way is by doing a lot of searching. Frankly, for a pending patent, you're going to look for published applications. And both the US Patent Office and the European Patent Office have pretty good websites in which they tell you what all the pending patent applications are. Your problem is going to be, what in heaven's name do you put into your search engine to find it? Do you know the name of the person who owns it? Do you know enough about the subject matter so you can be specific? Do you know the name of the potential inventor? You can run a search and it will probably tell you whether a patent is pending. Another question I might ask is, why do you want to know? Probable reason you want to know is you're deciding whether or not this is an area that you want to spend a lot of money, only potentially to be told to stop if somebody comes in with a patent at some time later. That's information that's worth having. You may also want to know, frankly, as far as I can tell, there's nothing out here, so I look in much better shape going forward for this, am I going to be able to use my idea, which was the subject of a few slides earlier. How can I draft a good business plan suitable for a grant? We had a slide in here, one of the previous ones, on what are investors looking for? And frankly, they're looking for pretty much the same type of information. Who are you? What's your market? What's your technology? Is this technology going to create a product? Is it going to be a better product? What's my timing to get this to market? Anybody's going to be look at that in a business plan, and there are, from playing a little on Google, there are a lot of people who've got template business plans, most of which frankly weren't half bad, that you can get out there. Take a look at them. Business plan by itself is a pretty good search. Suitable for a grant. Question this brought up to me is, in any business plan, you have to tailor it according to who's going to give you something. To whom is it directed? Grant people particularly have something problem they're trying to solve, problem in which they need research. Investors are looking for someplace they're going to make money. It typically isn't the main thing on a grant. There are a lot of social entrepreneurs who are really trying to solve a problem and looking for grants to do it. To whom do you submit a grant application? You submit the grant application to somebody else who thinks solving that problem is socially important. So how do you focus your business plan? Make sure that you remember to focus it on what the person to whom you're submitting it is really looking to do, or what return are they looking for out of the money that they're going to give you. Another footnote on this is, one of the things when I was Googling around, the World Intellectual Property Organization, WIPO, W-I-P-O, has a website. And one of the things they have on that website is I think it's a 5 or 6 page memorandum on how do you integrate, when do you have to integrate IP into your business plan. It's a pretty good outline. We touched on a lot of it earlier, But if your business plan includes IP, and in most, if you're listening to me, it probably does, take a look, go to WIPO and take a look at their how do you get IP into your business plan memo, because it's useful. This next one is a question that I frankly don't understand. If we're talking about, I don't understand what's meant by Creative Commons space. So how are we handling patents in 3D printing merchandising? I think generally you would handle the patents there in the same way you look at them anywhere else. How are patents going to affect what you can do in terms of 3D printing? What does your 3D printer look like? What type of product are you producing? And I think that's basically the same in any space. But as I said, Creative Commons kind of stumped me. So again, if the person who put this in wants to follow up and give me a little more background so I can give a better answer to the question, I'd be very happy to do so. Next to last, going to have some patents and trade secrets. I'm assuming from that at the moment you at best have pending patent applications, maybe provisionals, or maybe you haven't filed anything yet. But some third party is sufficiently interested in your technology that they want rights. What's the best legal strategy for me? I'd slightly change that question. The question I would ask is, what's the best business strategy for me? What do these people want to license? Do you want to put bounds on what you're going to license them? Do you want to put bounds on what you're going to be able to continue to do? Is this, you have plans on how you want to go forward and how, frankly, you want to make money out of this yourself. If it's premature and you're too early, are you going to get as much back as you might a little later, a little farther down the pike? There's nothing wrong with licensing to a third party early. If you and the third party really understand what you're both going to do with it, what you're both likely going to make out of it, legal strategies, you can write a very good agreement with this third party. It may be 75 or 100 pages long, depending on how big the business is and how much you're licensing. But it's a question of making sure that it's going to solve your business problems. And on your legal problems, what you want to make sure is, since you have not filed any patent applications, you're going to want to make sure that you don't jeopardize your rights to file those applications by inadvertently making something, turning it into prior art. And you want to make sure on the trade secret side that your trade secrets will be protected. You may think it's a lot more protected, and frankly, if so, you'll probably do a much better job of it than a potential licensee would. But these are largely all business issues that have to be solved, talked through, and frankly, reduced to a much more complicated agreement than anybody wants to pay for and write. Last question, what if you want to introduce an algorithm you wish to be free from patents? Publish it. The minute it's published, nobody's going to patent it. It's out there, it's prior art. Once it's been published, anybody who files a patent application after that, sorry guy, it's too late. Is that what you really want to do? How is to be free from patents? Do you want to hold on to anything else that's going to permit you better to stay working with your algorithm, to be sure that it's introduced in a way that it's going to be accepted and that you can ensure that you help people work? That's part of exactly how do you introduce it. You can certainly keep it free from patents. If you want to introduce it in a way that just basically you're sure it's going to get out there and it's free from patents, figure out who the people are that are going to be the most useful in getting it out there, and make sure that your arrangement with them makes very, very clear that there aren't going to be any patents. What's MIT's position on cryptography, information, and right for privacy? Well, if you went down slide 2 of session 1, I think I have talked someone at the MIT Technology Licensing Office to come on over on session probably 7, which will probably happen sometime in March, to talk about exactly what is MIT's position on ownership information. How do they handle data in addition to patents and types of things? I can't answer that question now. I'd probably give you a wrong answer, but I certainly hope that the woman who's going to come over and work through this will be able to. I've now got 4 minutes to 12. We have anything in?
Oh, we have a lot of questions. So first question, how do you prevent patent trolls?
You can't. The question, a patent troll, well, let's start off with who is a patent troll. To me, the real problem is the person who has a patent, they've got no product, so you can't sue them going back. And they're not just trying to make money out of this patent the way the law would kind of want them to. What they're doing is they're writing threatening letters that have utterly no basis, and they're willing to settle for something less than the $500,000 it would cost you to try to litigate the case, even though the case is worthless. There are some agencies, the FTC, that is getting into this. It's still a work in progress. If you get one of these letters, you might go first to the FTC and ask them what they're doing about it, and then try to find somebody who's really spending a lot of time working in this area, because there are people who are trying to solve a lot of the troll problem. Not yet successfully.
Next question. Let's see here. So this person is partnering with a third party, but is internally developing an app doing the same thing. And both are working in this same space, implementing the same standards. What is the proper methodology to document this person's development process to prevent IP infringements allegations? So it sounds like he's working for this company, but he's also doing his own thing.
Oh boy. Let me start off with something I might remember to mention later. If you are doing this jointly, you can have a joint development agreement, and its major effect will mean that one of your activities isn't prior art against the other. That works fine if your goal is to come out with a joint patent that you both will have some rights into and you can maybe assign to people. Beyond that, you're going to get into a lot of this, who's first in the race to the patent office. God knows, are you disclosing things you shouldn't disclose? It sounds like a potential mess.
Yeah,
I mean, it's not going to be easy to straighten out. If you really got an individual working for a company who doesn't want to assign everything she's doing to the company, but the company's also working it on it internally, I don't know how you resolve that satisfactorily to both the individual and the company.
Let me push that one step further.
Sure.
Would this potentially be a conflict of interest, and how would that
Yes.
work? Because it would be a question of loyalty, right?
You clearly get the question of what is your obligation of loyalty to your employer. And I think the general rule is that while working for someone else, to compete with them violates that duty. And if it doesn't, it's close enough that you're going to get into enough problems that you shouldn't do it anyway.
One last part to this. So in a lot of contract documentation, we see things like, you know, whatever you develop, an invention, patent, whatever it is, on the premises, in addition to that, off premises, off the clock, while in that employ, still could belong, you know, it could belong to.
As I think I mentioned when we were looking at assignment agreements, the most limited assignment agreement says any invention you make that's part of your job, I own. The most expansive is the type of one that you're talking about, that anything you think of or do from the day I hired you until after you quit belongs to me, and I don't care where you did it. read that agreement because you all will have signed one.
Okay. So let's see. There's a whole ton from the same person. I'm going to move on to probably one last question. But I'll send it to you anyway.
Please.
So you can. So Otto's asking, is it possible for a startup which has a competitive advantage in some telecommunication software developed in-house to pursue a business method patent to protect the operational behavior such software enables instead of getting a patent for the software itself?
Software itself, if all we're talking about is code, that's copyrightable.
And he references the Ellis case.
Yep.
And he says here, the downside of releasing the blueprint for the software is that giving you the competitive advantage which entities outside the US can abuse. So then it also seems like a...
Yeah, one of the problems, you can copyright software. One of the problems is at least the Copyright Office always wants a copy of the software. And the way people avoid giving away the entire business there is there are basically two ways to do it. It used to be first 10 pages, last 10 pages. You can also give them something where there's just big black lines going through 90% of it, so you can't possibly read the code anyway. You often are given the whole thing. In terms of the patent, and we'll get into this in patentable subject matter, it's beginning to break down that if what you are patenting is using a computer as a computer is always used to accomplish, to do something simply because it's faster and more efficient, is typically not patentable. If, on the other hand, what you are patenting is something that enables the computer to do something it couldn't have done before, to run faster, maybe in your telecommunications, a telecommunications routine that simply couldn't be done before, that type of thing is patentable. It's going to be very case specific. The cases are somewhat off the face of the map. The Patent Office has hundreds of examples for examiners to look at and little or no guidance as to what the hell they're supposed to do with it.
All right. Well, thank you, Jim.
You're welcome.
This is about the amount of time that we have for today. Don't forget, the next month we will have a teaching series from Jim, and then we will have a week-long question and answer period. Sounds like there's a whole ton of questions here. If you're interested in getting them answered in the Q&A session, that's where you really need to submit your questions, and please provide a sufficient level of clarity. That is important for us to review and analyze your questions so that we can answer it in a significant way.
And just from my point of view, if you can get these in by Andrew's initial cutoff date, it's very useful to me because it gives me a better opportunity to kind of sort things out, because some are closely related and some are not. This time we got relatively few questions in by the deadline, but I came back at the end of the weekend, having spent it with a grandchild, and Andrew had a longer list.
Okay, well, until next month, we'll see you then. Bye now.
Bye.